Welcome to People, Places, Planet Pod, the official podcast of the Environmental Law Institute, a nonprofit, nonpartisan organization working to ensure a healthy environment, prosperous economies, and vibrant communities founded on the rule of law.
Welcome to this week's episode of People, Places, Planet. I'm your host, Sarah Backer. Over the last 3 decades, numerous independent studies have concluded that Black, Hispanic, Native American, Alaska Native, Native Hawaiian, and working-class white communities are disproportionately exposed to environmental harms and risks throughout the United States. Recent studies have also concluded that although the adverse effects of climate change are being felt throughout this nation, the adverse impacts of climate change are not evenly distributed. Several states have initiated climate justice litigation to address this environmental and public health issue. In this week's episode, I sit down with Barry Hill, visiting scholar at ELI and former senior counsel for environmental governance of the Office of International and Tribal Affairs at the U.S. Environmental Protection Agency, and Emily Bergeron, associate professor in the Department of Historic Preservation at the University of Kentucky. We discuss their article, Climate Justice Litigation in the United States, a Primer, which examines how and why Rhode Island, Minnesota, and the District of Columbia have filed state law climate claims against companies that cannot be successfully removed to federal court. We also explore how tribes, acting as states, may want to consider filing climate justice litigation claims against companies in state courts. Barry and Emily, thanks so much for joining me today.
We're happy to be here.
On this podcast, we have discussed the growing number of youth-led climate cases. Most recently, we looked at Held versus Montana, wherein youth plaintiffs challenged state laws for failing to uphold their constitutional right to a healthy environment. So today, we are talking about how states themselves have initiated climate litigation. Can you please provide some context for the role states have played so far in climate litigation?
Well, states have played a very, very important role as far as climate litigation is concerned. And it's still evolving as a practical matter since the United States government has not been involved in climate litigation in the strict sense of the term. That's why there has been the reliance on states to get more directly involved with this type of litigation.
When Barry and I first started looking into writing this article together, we started looking through the Columbia database of climate litigation cases. And at this point, there are about 20 local and state governments that have sued fossil fuel companies. So there are states that have brought these claims, but also you can find cases out of Boulder, Annapolis. Lots of different municipalities and county governments have also filed these types of claims as well. Some of them are climate litigation, generally speaking, and a small subset of those are cases that are climate justice related.
Thanks, Emily. So your article looks at climate justice litigation in particular. Many of our listeners have heard us talk about environmental justice, but they may be less familiar with the term climate justice. Is this a new term?
Climate justice is in some ways a subset of environmental justice. The environmental justice movement started in the 1980s, and we're all familiar with the distributional disparities that are associated with environmental justice. And even though climate justice is sort of coming to the forefront right now in terms of what's on our radar from media, social media, those sorts of things, climate justice has been around just as long as environmental justice has. The first reference in an academic paper to climate justice was in 1989 by Dr. Edith Brown Weiss. She is a professor at Georgetown. And her work on climate justice started back in 1973. So even though it feels new because it's something that's coming to our attention with lots of climate litigation, climate justice itself is not really a new issue. It's not a new term. Essentially, what climate justice is as we face increasing problems relating to climate. So when we have hurricanes or floods or droughts, the people that are hardest hit by those disasters are usually poor and marginalized communities. And Usually these people bear less responsibility for climate change to begin with. It's about fairness, it's about accountability, it's about inclusion in decision making, much like environmental justice is. It encompasses environmental racism, it encompasses economic inequality, social injustice, all of these things that are exacerbated by environmental harm in general, but by climate change specifically.
That's really helpful. Thank you. So your article centers on sacrifice zones. Can you tell us more about what a sacrifice zone is?
For a moment, just think about Louisiana's Cancer Alley. This is a stretch that goes 100 miles or so to New Orleans from Baton Rouge. You have people living there, and these petrochemical companies and all kinds of existing industries. Now, as a result of breathing the air that's coming out of these smokestacks, people are getting sick. There are all different kinds of cancers. Basically, when you're saying that this is a sacrifice zone, the people that are living throughout that area, Cancer Alley, their lives are being sacrificed. Their health is being sacrificed for the good of the rest of the country. Let's take a simple thing like a plastic bottle coming from these petrochemical companies. We all use plastic, but the people who are breathing this air are disproportionately impacted as a result of industry being there. That's what the environmental justice movement was all about. Now, these same people who live in those communities, they're going to be impacted much more based upon the adverse effects of climate change. So we're talking about these same communities. We're talking about the residents of these sacrifice zones. And that's what the problem is. So when the climate justice movement began in the early 1990s, whereas the environmental justice movement, as Emily said, began in the 1980s, what they're talking about is equitable treatment as it relates to addressing climate. So that's what climate justice and environmental justice is all about, and what the definition of these sacrifice zones are. So again, just to think about Cancer Alley in Louisiana.
Thank you. So let's move to Kivalina, the first climate justice case. Can you tell us about this case and its implications?
Kivalina is a small Alaskan Native village sitting on a 6-mile barrier island in the Chukchi Sea. And this community used to be protected by sea ice. And because of changing temperatures, rising seas, now Kivalina has storm surges, coastal erosion, patchy sea ice, all of these things that interfere with the city's infrastructure, with their subsistence hunting and fishing, with their health. This erosion has been threatening this community for quite some time. And the village of Kivalina brought a claim against a number of companies claiming that climate change, as a result of what was being done by these companies, was threatening them and requiring them to move to a more stable area. For communities like Kivalina, this land is not fungible. You can't move a community that has such specific ties to this land from a cultural preservation perspective, social ties, economic factors. It's not easy to just pick up and move your community. So this claim was brought alleging that as a result of climate change, the Arctic sea ice that protected Kivalina from storms was diminished, and the erosion would cause the village to be required to relocate. The expense of that would be somewhere between $95 and $400 million. Kivalina's charge was that there was a breach of federal common law and of public nuisance for unreasonable discharge of greenhouse gases. The claim was dismissed because it was found that this was a federal case and it was not able to be answered in federal court. The Kivalina case was dismissed for lack of subject matter jurisdiction, deemed that climate change was more of a political question and wasn't appropriate for federal court. There was also a consideration as to whether or not future plaintiffs could be required to establish proximity to pollution to establish causality, but this was ignored in that dismissal.
The Kivalina case was brought, as Emily said, in federal district court. The problem that any plaintiff would face is that Well, whether or not the federal court has jurisdiction to hear the case and resolve the case. In the Kivalina situation, the court determined, as many federal courts have determined, this is a political question, something that should be handled by the Congress, the president, the voters. We don't have any control over what's before us. So the states look at what happened in Kivalina, the first climate justice case, and they said, "But we're going to learn from what happened. We're not going to go to federal district court. We're going to file our claims in state court. In addition to that, all of our claims will be based upon state law. There will not be any reason as a practical matter for this case to be removed." So they said, we're going to go to state court. We're going to use state-based claims, no federal claims at all. Kivalina, yes, it was the first climate justice case, but it was brought by a nonprofit legal corporation representing Kivalina, and they went to federal court. Excellent arguments, but they were federal arguments. In federal court, where a federal judge does not have jurisdiction. So what happened in all of these cases brought by the state attorney generals, there was a jurisdictional dispute. The Supreme Court in all of these cases said, stay in state court. These are very, very pitched battle, if you will, as far as jurisdiction is concerned. All of these cases are moving towards a jury trial. Jury trials are people who are going to sit on these juries, regular citizens in the states, to hear these disputes. That's where things are at this particular point. So in conclusion, the Rhode Island case, the Minnesota matter, and the District of Columbia plaintiffs, they're just a few of dozens of states, cities, and towns in the U.S. and its territories who have filed lawsuits in state courts aimed at holding companies accountable for climate damages and deceiving the public about the harm their products have and will continue to cause.
Do you have a sense of the outcome of these cases?
It is absolutely too early to speculate, but the fact of the matter is that these cases, based upon Supreme Court determinations, they will stay in state court. That's the beauty of these cases. It will not be a Kivalina where a federal district court judge will say, I don't have the authority. The Supreme Court has said that no, state judges will hear these cases. These cases can be used as lessons learned as far as other jurisdictions are concerned throughout the United States in order to move this idea forward of climate justice litigation.
A lot of your article focuses specifically on how tribes acting as states can potentially consider filing climate justice litigation claims in state courts. So why do you choose to focus your research on the Navajo Nation?
Between Barry and I, that was an evolving discussion. In this country, there are more than 700 communities and tribal nations. They all are culturally, politically unique groups, and they are across the country, all have different relationships with federal, state, territorial, local governments. They all cut across really diverse ecosystems. So they're all facing very different environmental impacts as a result of climate change, but they all are facing impacts on livelihoods, on health, on nutrition, on cultural practices, impacts on sacred sites. All of these things are impacting their resilience. And Barry and I talked a lot about a variety of different nations that could bring claims, briefly talking about how these claims could be brought in tribal courts. Tribal courts do have limited jurisdiction over non-native actors. There's a Montana v. United States exception that allows tribes to bring claims in tribal courts for direct effects. So where there is authority to bring a claim against someone like a company for causing harm to the health and welfare of the tribe. But we really arrived at discussing the Navajo Nation as a potential litigant as a result of the Supreme Court's decision in Arizona v. Navajo Nation. This is where the Supreme Court held that the government does not owe any affirmative duty to the Navajo for secure water. And the issue of water scarcity is something that is really central to a lot of climate litigation, a lot of climate action, and it's really very central to climate justice. So that's how we arrived on discussing the Navajo in this particular instance.
And let me add that this is a recent decision that the Supreme Court reached. This was July 24th of 2023. And that was a 5-4 majority decision. And writing for the majority was Justice Kavanaugh. And as Emily said, the United States had no affirmative duty to assess the Navajo Nation's water needs, to develop a plan to secure the needed water, and to potentially build pipelines, pumps, wells, or other water infrastructure. No affirmative duty. So what are the Navajos supposed to do when they're being impacted by climate change? And there's this Colorado River that runs parallel to the reservation. What do you do? What do you do when 30% of the homes on the Navajo Nation don't have running water? What do you do? Continue to drive many, many miles to purchase these 55-gallon drums full of water that are very expensive. How do people live when there's supposedly a human right to water and sanitation? Tribes are considered states under federal environmental laws, including the Clean Water Act. The Navajos had wanted to be part of the discussion, to be at the table as the dwindling water was being parceled out between the various states, 7 states that get water from the Colorado River. And the Navajo tribe, as I said, the Colorado River runs parallel to the reservation, but they don't have any access to that water. So that's the thing that spurred us to look at the Navajo Nation, use that as an example. And of course, we don't represent the Navajo Nation in any way. We're just researchers, lawyers, trying to come up with something that made sense. That's why we focus on the Navajos, because other tribes, as Emily said earlier, have brought matters in state court related to climate justice. And then we looked at the laws of the state of New Mexico, whether or not there was something there that the Navajos, if they decide in their infinite wisdom to move ahead with something like this, because they were in a situation that a lot of their residents did not have running water. So what do you do under those circumstances? So what we did is that we sought to be creative and to see what's happening in New Mexico as far as the law is concerned, what's happening as far as the leadership is concerned in the state, as far as the governor is concerned.
What do you see as the ultimate goal of your article?
We're just trying to light a match. It's up to the Navajo leadership to make that determination, as it would be with any other tribe. All we're basically saying is that based upon the laws, you can bring an action in state court in order to address the concerns of the people. And using what the states have done, as a practical matter, we can, as tribes, learn what's going on, and we can use those same tools to address the concerns of the people who live on the reservation. But they're the only ones who can make those decisions.
Two, it's important to recognize that of the thousands of treaties that exist between the federal government and the tribes, none of them are enforced correctly or 100%. So to see something like Kivalina and to see that case dismissed because of the questions being raised, it does point to trying to find some sort of alternative for finding a way to support people. I think that you see that there's an opportunity for some change that is available to tribes. Barry talks about everyone deserving a seat at the table. And one of my favorite statements that Barry makes frequently is that if you don't have a seat at the table, you're probably on the menu. So I think that if this type of litigation can provide that seat at the table, I think it's really important to move forward with this.
Well, Emily and Barry, thanks so much for joining me to discuss your ELR article, Climate Justice Litigation in the United States, a Primer. I encourage all of our listeners to read this article, which will be linked in our show notes. Once again, Barry and Emily, it was a pleasure learning from you.
And thank you. We really do appreciate it.
Thank you for tuning in to People, Places, Planet Pod, brought to you by the Environmental Law Institute. We would like to hear from you, so please send us your questions, comments, and ideas to podcast@eli.org. And if you're interested in learning more about our work, attending one of our events, reading our publications, or becoming a member, please visit our website at www.eli.org.